Ladies and gentlemen, we are privileged to have with us today Right Honourable Sir Geoffrey Vose, Master of the Rolls and Head of Civil Justice of England and Wales. Sir, your presence lends great distinction to this gathering, and we look forward to your insights into the future of arbitration and judicial support for international commercial arbitration. Please join me in welcoming Sir Geoffrey Vose while I invite him to deliver his keynote address.
Honourable Chief Justice of India, ladies and gentlemen, thank you so much for inviting me to contribute to this extremely important conference. I've been asked to address the subject of strengthening the India-UK economic corridor, the role of ADR in cross-border trade and investment. And I've actually visited India on more than a dozen occasions in the last 25 years. And on each occasion I go to India, I visited courts in Mumbai, Kolkata, Delhi, and all over the country. And I've also had the privilege of being shown at first hand the immense efforts that are being made to digitize the Indian courts. I had the privilege of spending a day sitting with the former Chief Justice Chandrachud in the Indian Supreme Court in late 2024, and I observed the extensive usage of AI by the Indian judiciary, including in producing simultaneous transcripts of the proceedings. And I know that Chief Justice Surya Kant is continuing this process enthusiastically. You will know that I have been intimately involved too as head of civil justice here in England and Wales in the digitization of the justice system of England and Wales, and in the creation of our digital justice system, which aims to resolve all kinds of dispute online without the need for lengthy and costly analog legal proceedings. I believe that close, friendly relations between the major common law jurisdictions of the world is becoming increasingly important in the new digital world in which we live. And in this short address this morning, I'm going to try and explain why that is the case, and why these relationships are equally important to international arbitration in our two countries. But let me start, perhaps eccentrically, by referring, if I may, here in Church House, to Pope Leo XIV's encyclical last week entitled Humanita Magnifica, on safeguarding the human person in the time of artificial intelligence. Much of it is about the critical subject of digital sovereignty. Paragraph 67 of the Pope's encyclical says that its context is where the wealth of nations depends increasingly on knowledge and technology. And when these goods remain concentrated in the hands of a few without adequate forms of sharing and access, a new imbalance, he said, is created. And he talked of the widening gap between the included and the excluded, and called for the new possibilities offered by technology to be regulated in such a way as to respect the environment, avoid waste, and prevent new forms of exploitation. It seems to me that the Pope was speaking of two forms of digital exclusion: the exclusion of many nations from their own digital sovereignty, and the exclusion of many of the world's population from the economic advantages afforded by ever more capable AI. And these two forms of digital exclusion are more than relevant to both India and the UK, because neither country is free of outside influence. The UK benefits from a linguistic advantage in that it can make full use of US-based LLMs and AI systems founded on the English language, whereas India has multiple languages, which create challenges for bringing large language models to the entirety of her population. But both countries are dependent on the technological sovereignty of big corporate developers in other countries, including, of course, the USA and China. Dependable systems of private law and efficient and economical commercial dispute resolution are both far more important to the economic success of our nations than many people would recognize. Let me explain what I mean. It has long been understood that reliable overseas investment in all our countries is dependent on the rule of law. Unless overseas investors are confident that a commercial dispute with the government of the home country will be resolved fairly, within a reasonable time, and at proportionate cost, such investors will go elsewhere. This principle applies as much to arbitration as it does to court-based dispute resolution. This principle also applies with even more force to the availability of AI. Our economies in India and the UK now depend on the availability of increasingly capable AI to all our industrial and financial markets. As the current international conflicts emphasize, global economies are fragile and can easily be disrupted and damaged by events. So there is perhaps a golden opportunity for our two countries to work together to ensure that our populations are not excluded from access to ever more capable AI, and that each of our countries can retain its own digital sovereignty, governed most importantly by our own domestic laws. Now, I'm sure everyone here will be aware that in December 2025, the AAA, the American Arbitration Association, its International Center for Dispute Resolution, launched an AI machine-driven arbitrator for two-party document-only construction disputes. The AI arbitrator has a human in the loop in that the outcomes and draft awards proposed by the machine will be evaluated by a human arbitrator. But that human will review and test the AI's reasoning and evaluate the decision to safeguard trust, transparency, and due process. I don't think the AAA has yet published any analysis of the take-up of this process, but it's likely that it will be adopted because AI arbitration and AI-driven ADR have some considerable advantages over court-based dispute resolution by human judges. Those advantages, of course, are cost and speed. And AI-driven solutions of the kind I've mentioned are far easier to introduce in the arbitration context, where the parties have autonomy and where there's no judicial arm of state involved in the process. So it's worth pausing to note that AI-driven judicial dispute resolution is complex for reasons of constitutional and democratic legitimacy. It would not, as it seems to me to be possible, for the judiciary in any democratic country to use AI to make its decisions of its own volition, because it is a central tenet of the rule of law that the state provides an independent judiciary fairly to resolve disputes between citizens and between business and citizens and between them and the state. And it's not yet been established that a machine can constitute an independent and impartial tribunal for the purposes of, in this country, Article 6 of the European Convention on Human Rights, and in India, Article 14 of the International Covenant on Civil and Political Rights. We do, though, of course, see AI already being used to facilitate judicial decisions in China, Argentina, and Brazil, but not in many other countries where legislation would be needed to allow those decisions to be taken by AI. The crucial difference in ADR and in arbitration is that the parties can consent to resolve their disputes in any way they choose. And in arbitration, consent is usually given in a contractual context in advance of the dispute arising. So to return to my theme, if cross-border investment is to be promoted in the India-UK corridor, effective dispute resolution in general and arbitration in particular is critical for the reasons I've mentioned. It seems to me that the international legal community should be astute to ensure that the common law foundations for our alternative dispute resolution mechanisms are our domestic legal systems. If AI systems are to be used in arbitral decision-making, the underlying LLMs must be trained on materials that are relevant to the home states of the parties involved in the disputes. If AI is actually to take decisions or even to inform human decision-making as to the outcomes of cases, whether in ADR or in a judicial context, there has to be the creation of reliable models and LLMs that are trained for that purpose and extensive testing of their reliability and biases in decision-making. It's possible that when we do have our first machine-made arbitral decision, there will be challenges to its enforcement under the New York Convention public policy provisions. Machine-made arbitral decisions, though, may become very attractive to commercial parties in terms of time and cost. But the legal community must ensure that the digital and legal sovereignty of our jurisdictions is maintained so that those decisions are just and reliable. Should we be worried from a rule of law perspective about these developments? Well, I think not, because it is one thing to impose machine-made decisions on parties to court proceedings who might justly claim a constitutional right to a decision made by a human judge. But it's another thing to allow the parties to choose a process that expedites their decision-making by which they've agreed to be bound. So let me conclude by suggesting, as I often do, sometimes without much effect, that the legal community must move with the times. As I said on Tuesday at the LIDW's main panel, none of these changes that I talk about frequently is likely to be reversible. The world will not go backwards. Instead, these changes will accelerate, and the legal community needs to find ways to make itself relevant in the new world order, to adapt and change. And in order to ensure that we encourage and promote cross-border trade, we must make sure that we embrace AI solutions to legal problems. But, as I say, and I think this is very important, those AI solutions must have their foundations in our own laws, in the laws of India and England and Wales, in our own legal traditions. If we are to adopt AI-assisted arbitral decision-making, we should train and test the AI tools we're using on materials that are relevant to the states of the parties involved in the disputes. Thank you very much for your attention.
Thank you, sir, for your erudite address. Your remarks have set a strong foundation for the discussions ahead. Ladies and gentlemen, please join me in welcoming Honorable Justice Suryakant with another thunderous round of applause as we invite him for the inaugural address.
The Right Honourable Sir Geoffrey Charles Boss, Master of the Rolls and Head of Civil Justice of England and Wales, Mr. Karthik Pandey, Learned Deputy High Commissioner of India to the United Kingdom, Mr. Brett Dixon, Vice President of the Law Society of England and Wales, Dr. N.G. Khaitan, President of the ICA, Mr. Arun Chawla, Director General ICA, eminent former judges and very eminent senior advocates from the Supreme Court of India, other parts of the country as well as from England, learned former judges, distinguished panelists, practitioners, arbitrators, and friends from the world of law and commerce, friends from media, ladies and gentlemen, I am truly delighted to be here at Church House to inaugurate the 4th International Conference of the Indian Council of Arbitration. At the very outset, I would like to extend my heartfelt appreciation to the ICA, the organizers, for bringing together such a distinguished gathering from the world of law, commerce, public policy, and dispute resolution. We meet at a significant moment in the relationship between India and the United Kingdom. May I just at the outset also point out that I am sharing my views with reference to the arbitration or the alternative dispute resolution mechanism as a catalyst for strengthening Indo-UK economic partnership. So in that context, I was saying that we meet at a very significant moment in the relationship between India and the United Kingdom. Ours are two common law jurisdictions with a long legal conversation between them. They are also two economies seeking to give fuller meaning to a deeper commercial partnership. This significant endeavor requires confidence that when disagreements arise, they will be resolved fairly, efficiently, and with respect for commercial realities. It is in that spirit that I wish to speak about arbitration today. Also, as head of the Indian judiciary, knowing fully well that we are facing one of the challenge of pendency, I am not only a big stakeholder in arbitration, but if you permit, I would say that I am a co-partner in the arbitration family. At its best, arbitration brings to commercial disputes expertise, neutrality, confidentiality, finality, and practical good sense. It is for these reasons that it has found acceptance across jurisdictions and legal traditions. Yet respect for any institution requires more than praise. I am thankful to the organizers that in a video clip they had shown my two previous participations on the ICA platform. One probably in 2019 and the other one was in 2026 only after I took over as Chief Justice of India. And in continuity only and being deeply concerned and deeply appreciating the arbitration as a very robust and effective mechanism which is addressing most of the commercial challenges in India and of course across the world, that some of the issues I thought that this is the intellectuals occupied platform where I should raise these issues. The arbitration, when we are referring to, it also requires us to ask with candor where it may have drifted from its founding purpose and what must be done to restore that purpose. But before I can assess what is lacking in international arbitration today and speak loftily about strengthening the UK Indo ADR framework, we must first be clear about what it was meant to be. Ladies and gentlemen, arbitration did not begin as a creature of a statute. I know that all of you are aware, but I'm just refreshing the memories. It did not spring into life with the English Arbitration Act of 1889 or India's first arbitration legislation of 1899 or even the New York Convention of 1958. Those instruments merely recognized, regularized, and regulated a practice that commerce had already developed centuries. As the story goes, when medieval merchants of different nations met at the great trade fairs of Champagne, they could not rely on any single state's courts. They could not wait for expensive and formalistic litigation. They needed decisions quickly from people who understood their trade. And that experience gave rise to the Lex Mercatoria or the law of merchants. And in India, I would say that instinct of community-based dispute resolution was even older. The ancient panchayat system, which placed its trust in the village elders, was resolving commercial disputes long before any arbitration statute came into existence. The principle was the same. Justice is most legitimate when it is chosen freely, delivered by someone who understands your world, and proportionate to what is actually at stake. Arbitration is simply what happens when you take this instinct and give it a framework. Its central question is simple. When parties in commerce disagree, how can their dispute be resolved in a manner that is fair, informed, timely, and final? All rules, institutions, and enforcement mechanisms exist to serve this central question. The difficulty begins when the machinery overwhelms the purpose. If arbitration becomes too expensive, too slow, too closed, or too formal for a parties it is meant to serve, then the institution must look within. Ladies and gentlemen, despite its many successes and millions of successful stories, international arbitration today faces a few structural challenges. I believe this has occurred at least in part because arbitration has increasingly come to be treated as a product to be promoted rather than a mechanism to be refined. At times, one is reminded of an automobile expo where every manufacturer is eager to showcase the virtues of its latest model. In a similar vein, institutions, practitioners, and stakeholders often compete to highlight the attractions of arbitration, sometimes with greater emphasis on its commercial appeal than on the practical objectives it was intended to achieve. The consequence is that the conversation can occasionally shift away from the parties and businesses whom arbitration exists to serve and towards the industry that has developed around it. For instance, in high-value international arbitration, appointment patterns have often appeared concentrated. A relatively small pool of repeat participants appears with frequency as arbitrators, counsel, and experts. This is not by itself evidence of impropriety, I must admit. Most of us would agree that expertise is often built through repetition, but concentration can create a strong perception that arbitration is distant and difficult for others to enter. The concern is visible also in the cost and duration of many proceedings. In some cases, international arbitration has absorbed the very habits of litigation that it was designed to avoid. Heavy pleadings, multiple procedural rounds, long hearings, and fee structures that many users find difficult to bear. Arbitration agreements, unfortunately, are at times drafted with a level of complexity that rivals a legal treatise. Instead of providing certainty, they frequently contain ambiguous language, overlapping provisions, and imprecise formulations that leave critical questions unresolved. The result is often a preliminary round of litigation devoted not to the merits of the dispute, but to determining foundational questions, namely, whether a valid arbitration agreement exists at all, which law governs it, where the jurisdictional seat is located, whether the chosen venue carries legal significance, and who possesses the jurisdiction to decide these issues. By the time these threshold questions are resolved, parties may find themselves engaged in extensive litigation merely to establish that their dispute is, in fact, one that must proceed to arbitration. Similarly, the principle of party autonomy, which is often described as one of the defining strengths of arbitration, has in certain respects, in my humble opinion, come to be misunderstood and stressed beyond its intended purpose. Increasingly, one encounters situations where party autonomy is equated with an unrestricted ability to select particular adjudicators, a practice that can sometimes give rise to concerns regarding perceptions of neutrality and confidence in the arbitral process itself. In many common law contexts, comparable attempts to secure a preferable form of decision maker would attract close scrutiny, and it may amount to form shopping even. Yet within arbitral discourse, such practices are occasionally defended under the broad banner of party autonomy. In my view, this reflects a misunderstanding of the principle. Party autonomy was never intended to mean that parties are entitled to engineer the identity of the decision maker, most likely to favor their position. Rather, it signifies the right of the parties to insist upon a process that is independent, impartial, fair, and capable of inspiring confidence in its outcome. When disputes over appointment themselves become the subject of prolonged challenge before courts, the process begins to undermine the very efficiency and credibility that arbitration seeks to provide. It may therefore be worthwhile to consider whether clearer guidelines, institutional safeguards, or more developed doctrinal principles, particularly, we need to strengthen the institutional arbitration that are required to ensure that party autonomy remains a guarantee of procedural fairness rather than a source of procedural contestation. What these issues amount to are a form of institutional self-consumption, which we must guard against. Arbitration was built to be the answer to the pathologies of formal litigation, and it is seemingly acquiring each of those very failings. In other words, the remedy has come to resemble the disease it was designed to cure. Therefore, my dear friends, that transformation did not happen in a day. And reversing it will also not happen unless we collectively commit ourselves towards that cause. It will require, for instance, organizations to champion the international adoption of best arbitral practices, conferences with timely themes like this that demand institutional reflection, and a globally collaborative approach among genuine and ethical platforms. Turning to the theme which I opted to speak, the ADR as a catalyst for Indo-UK business relationship. Just last year, the India-UK Free Trade Agreement was concluded. which was an unquestionably historic moment for both nations. Because at a time when international trade discourse is marked by strain and uncertainty, India and UK showed the world a better way forward. The FTA is expected to increase bilateral trade between the two nations, and as I was reading in a newspaper, by an estimated US dollar 34 billion a year by 2040. This is indeed an aspiration of extraordinary ambition. But ambitions are realized in contracts, not in communiques. The Indo-UK economic partnership cannot be strengthened by trade agreements, tariff schedules, and investment announcements alone. It also needs an ADR architecture that converts commercial confidence into day-to-day practice. And it is that apprehension of the structural failure which I just thought to highlight and describe that stand most directly between aspiration of the FTA and the commercial reality it is meant to enable. In the conference, the first session is very meaningful because the first session today asks how ADR can strengthen the Indo-UK economic corridor. To my mind, the answer begins with confidence. A corridor is not strengthened merely because goods, capital, and services are allowed to move across it. It is strengthened when those who use that corridor know that if something goes wrong, they will not be priced out, delayed out, forced into a process that had no real power to choose. In many cross-border contracts, including those that will multiply under the FTA, smaller exporters, suppliers, startups, and medium-scale industries accept seats, rules, and fee structure chosen by stronger counterparts. So while their consent is legally valid, their practical choice is often thin. We must therefore introspect how to ensure equal level play field for all. This is not a peripheral concern, especially when we know that the next wave of Indo-UK trade will not be carried out by conglomerates. It will be carried by pharmaceutical suppliers, fintech firms, clean energy business, digital platforms, and mid-markets manufacturers on both sides. If our ADR mechanisms work only for disputes large enough to justify high fee or large legal teams, that might fail the very commercial partnership that are meant to support. Real party autonomy, therefore, requires accessible model clauses, transparent costs, diverse panels, digital case management, and procedures proportionate to the value and urgency of the disputes. In short, the autonomy that arbitration promises must be made genuinely usable for all parties to the corridor, not just the most powerful ones. There was a time when India's arbitration conversation was framed as an effort to catch up with London's gold standard. That framing may have become obsolete and even an obstacle to the very co-creation this partnership demands. Consider what has happened simultaneously on both sides. The English Arbitration Act 2025 recently received royal assent, concluding a 4-year process of modernization. India's Bar Council in May 25 amended its rules to allow foreign lawyers and firms to operate in India in varied sectors, opening the doors for the cross-fertilization of legal talent into the Indo-UK corridor needs. Our Mediation Act of 2023 gives India one of the most developed statutory framework for mediation enforcement in India, and the FTA itself has created the commercial impetus for all of these to cohere. These are signs of convergence between two mature common law systems that have each developed sophisticated, independently reasoned ADR cultures. What is needed now is not comparison, but co-creation. The task is to design together an ADR corridor that in which both systems lend each other credibility, talent and standards, ultimately building something neither could build alone. And this brings me to the second session of this conference today, which asks us to look beyond silos and architect hybrid ADR ecosystems for complex Indo-UK commercial disputes. I believe that question awakens us to the reality that it is not enough to have two parallel systems, each excellent within its own jurisdiction, running side by side without connection. What the FTA's commercial reality demands are hybrid mechanisms, arbitration mediation protocol that preserves commercial relationships rather than destroy them, joint institutional framework that build shared arbitration panels and digital platforms that make these mechanisms accessible to businesses of every scale. This is where co-creation must begin. With that goal in mind, allow me to suggest 3 concrete steps that are within the reach of the institutions. I'm talking about the arbitral institutions representing in this room. First, build informed neutrality. Friends, geographic neutrality alone is no longer sufficient. A tribunal may be seated in London and still be unfamiliar with Indian regulatory realities like medium standard entrepreneurs, contracting practice, or the significant jurisprudential developments of the last decade in Indian commercial law. Likewise, a tribunal in India may misread English commercial expectations. I therefore believe that a joint Indo-UK arbitrator accreditation and cross-training program should build a shared pool of practitioners genuinely fluent in both ecosystems and begin directly to dismantle the exclusivity I described earlier. Second, create a swift track protocol for the missing middle. The FTA will generate disputes, maybe relating to technology licensing disputes, fintech partnerships, breakdowns, and so on. For these, institutional arbitration framework should be suitably provided, and that platform should be something which is acceptable and affordable by all of them. This will require a capped fee, a primary documentary procedure, online hearing where appropriate, a short mediation window, and a defined timetable for final determination. And the third suggestion is connect arbitration with mediation through properly designed hybrid protocols. Many Indo-UK disputes will arise within continuing relationships, joint ventures, distribution networks, technology partnerships, infrastructure contracts. In all such relationships, the best outcome is often not a winning award, but a preserved commercial relationship. India's Mediation Act 23 and the growing mediation culture in the United Kingdom give us every foundation we need to build protocols that are properly safeguarded for confidentiality and impartiality. Let me conclude by reiterating that arbitration does not need another ceremonial tribute to its past. It needs a serious recommitment to the reason it came into being. Contemporary international arbitration asks parties for a profound act of trust. When they step away from their national courts and submit their disputes to a private tribunal, they are entitled to expect a process that is fair, proportionate, and timely. They are entitled to expect that the tribunal will understand the dispute, that the procedure will not overwhelm, and that the award will bring certainty. That is why, and I said in the beginning, the merchants of champagne will still matter. They did not wait for a perfect institution or a perfect legal order. They built what commerce needed with the tools available to them. Because unresolved disputes, broken trust, and stalled trade were too costly to tolerate. The same insight animated many of our own local traditions of settlement in India. Today, our task is similar. We must ensure that arbitration is not a privilege of scale, but an instrument of justice. And of this conference helps move us even modestly in that direction. It will have served a purpose beyond deliberation. And I know the participants, the stakeholders, the leaders of ICA, that they're being committed to these issues to bring affordability, timeline, certainty, productivity in arbitration, that I chose to flag these issues before all of you. I congratulate the ICA for organizing such a meaningful deliberation. I hope that the technical sessions will undoubtedly address those issues which I have tried to raise before you and will respond with befitting answers. With this, I take your leave and wish the deliberations of this conference a very success. Thank you very much for inviting me and giving this opportunity to share my views. Thank you very much. Thank you.
Ladies and gentlemen, I request the speakers for the session 2 to kindly take their seats on the dais, please. We now turn to the final session of the day on strengthening the India-UK economic corridor, role of ADR in cross-border trade and investment, which, after what has truly been an intellectual marathon so far, promises not just to conclude, but to catalyze further thought and discussion on the evolving role of ADR in strengthening cross-border trade and investment between India and the United Kingdom. It is my privilege to invite the moderator and speaker for this session, Ms. Karishma Vora, barrister and international arbitrator at 39 Essex Chambers, a distinguished practitioner with deep experience in international arbitration and complex cross-border disputes. We welcome you, ma'am. We are also joined by a distinguished panel of experts from India and the United Kingdom, each bringing rich and complementary perspectives to this closing discussion. From the Indian and global interplay side of the conversation, we have with us Mr. Nitesh Jain. He's partner in the dispute resolution practice at Trilegal India, with extensive experience in complex commercial disputes and arbitration. Mr. Abhijit Mukhopadhyay is president legal and general counsel at Hinduja Group. He's based in London, bringing a seasoned in-house and global corporate perspective on cross-border legal strategy and risk. Speaking for the United Kingdom perspective, we have with us Mr. Fraser Campbell Casey. He's a barrister at Blackstone Chambers, UK, and a leading counsel in high-value international commercial and arbitration disputes. Ms. Amanda Clark is CEO of HKA and chair of DARB at Rex UK, with extensive expertise in dispute resolution advisory, risk, and infrastructure-related claims. Together, they bring together an advocacy, education, in-house leadership, and advisory expertise, offering a well-rounded perspective to distill today's discussions into actionable insights for practice and policy. I now request Ms. Vora to kindly take over and steer this discussion forward.
Thank you, Akshita, and thank you to the Indian Council of Arbitration for always bringing together a great cohort of people, and to all of you for sticking to what I think we will all agree is the graveyard shift before lunch. We'll be brief. And in case we're overrunning, I will ring the glass to ensure that all of our speakers allow us to proceed to lunch quickly. So, we're here today to discuss on this particular panel, strengthening trade, investment, and commercial relationships. And yet, somehow, we have assembled a panel comprising almost entirely of people whose careers depend on those relationships going wrong. Business persons seem to be able to price risk. They seem to be struggling with pricing uncertainty. And so what I would hope that this panel gives us by the end of our session is some sort of certainty about the way forward. Starting with the Indian perspective, Nitesh, if I can call upon you, I think the biggest sort of elephant in the room as far as Indian disputes is concerned is the pendency of court cases. So how do you think that can be resolved?
Good afternoon, everyone. Thank you, Karishma. I was checking earlier today, and so in India we have the national sort of grid system, judicial grid, where you can see the pendency of cases live, right? There's a data, and it's updated sort of every day, right? India has around 50 to 55 million cases pending, right? While these are the numbers that show that how many cases are pending, but on a daily basis, there are thousands and lakhs of cases that are disposed of every day, right? And this, of course, excludes the arbitration and the quasi-judicial sort of cases that are ongoing in India. Courts are overburdened. There are delays. As far as arbitration is concerned, we have made significant progress over the last 10 years. There have been series of amendments in the arbitration basis what's happening in India and outside. There are judicial developments, but sort of the government is very proactive in making those changes, right? But I think the change that has to happen in the resolution culture, so to say, right? It has to be something which is other than the court litigation and arbitration, which is where everyone is now pushing for mediation, right? I think that's the sort of quickest, the most efficient, cost-effective, practical way, in terms of business sort of the requirement, right? That's the best way to sort of resolve a dispute, right? 2023 is when the Mediation Act came in India. The idea is to sort of strengthen the resolution culture, to sort of make it more efficient. This is on the lines of the Singapore Convention. India is a signatory, but India can't ratify it till such time we have our own domestic legislation. That's why we had, right? The system is working very well. And just to sort of, I was hearing the earlier panel, right? The mediation is not to replace arbitration. These are two different things altogether, right? The idea is not to litigate. The idea is not to arbitrate, right? The idea is two business parties, they're sitting together. You have a mediator. If you're able to resolve it, lawyers are kept outside the room. Of course, they're there to guide you. The idea is to sort of resolve it quickly. In the Indian context, mediation is not for the first time that it has come under the 2023 Act. It's been there under the Indian CPC, since 1908. Various high courts in India, they have their own mediation cell. The matters are referred by the courts to mediator that please go and try this mediation, and it is actually working. Delhi High Court has its own mediation cell. They have their live website. If you'll see it, you will see data for last 10 years. They will explain to you 45,000 cases have been referred. These have been decided. These were unsuccessful. There is a proper sort of statistics that's working, right? So I think the sort of the way forward and how the world is moving, right? And India has FTA with the UK, with EU, right? The trade's gonna increase by billions and billions, right? I think London will have sort of added advantage in the India-EU, the FTA, right? Because, London being sort of a neutral place, right? So all these things, I think, if you have to move fast, the most effective way is to think about ADR, is to think about process like mediation, where you think about changing the culture of sort of resolution.
Thank you, Nitish. So I think that it seems that we can take a leaf out of some other countries. For example, in Australia, a significant number of court cases were reduced by the introduction of mediation in the 90s. Fraser, just a quick comment from you. Is it possible, or do you think that it has already begun to reduce cases in the UK?
Thank you. Yes, I think very sadly, from a barrister's perspective, mediation does reduce cases going to court. I think the one point I'd make is there's been discussion earlier on, as there often is in arbitration, about do you want med, arb, med, do you want arb, med, med, do you want arb, arb, med, med, med. I think the thing to bear in mind, I think, is that mediation doesn't have to be just a one-off showpiece event where you have a mediation day and it either works or it doesn't. Mediation can be used as a tool on an ongoing basis throughout a process in parallel with litigation or with arbitration. It can go in fits and starts and eventually succeed, or it can partially succeed if it takes some issues off the table and reduces the scope of dispute. So that's something I often advise clients. Don't think of it necessarily as something which is tried and then either works or doesn't.
Thank you. So it doesn't have to resolve the entirety of the dispute. It can take a few issues out of the case and narrow the issues in the case. Thank you. Mr. Mukhopadhyay, coming back to you. You bring a very valuable industry opinion to this panel. And my question to you is, how does one preserve the commercial relationship amidst a dispute?
It's a $1 million question. It is like I'm fighting with my wife, yet maintaining good relations. I really do not know how does it happen. This is such a vast subject. I think I need one day to complete my conversation. Let me tell you like this. We are a commercial organization. Throughout my life, I worked only in-house commercial organization, many in India, some of the best known companies in India, and then here, of course, for the last so many years. I always say that don't get into any kind of dispute. Now, when I was young, I was very enthralled the moment a dispute came, and then the court process, litigation, etc. But when I try to, go beyond that, become quite matured, I thought that dispute is not a very ideal thing that as a commercial organization we will have, because I may win a case, I may win an arbitration award, but at the end of the day, I am losing a customer, I am losing a joint venture partner, I am losing my future joint venture partners, and at the end, there is news all over that we are a very litigious kind of entity. So it does not do any good for any commercial organization, whatever they may say, because the idea is not to make some money out of the process. Now, it is easier said than done. I will try to tell you in next 1 minute, because Karishma already threatened, we have got only limited number of minutes available with us. I'll tell you like this. I have got great interest in developing relations. So when I negotiate with the other side, I don't take them as our adversary. I have to fight. So if you say yes, I will say no. If you say 1, I will say 1.1. That cannot be the approach. I'm only talking about multi-billion-dollar negotiations. So therefore, try to understand from where the other side is also coming from. Similarly, try to ensure they understand your viewpoints also. And once that happens, we are in perfect peace with each other, at least for the time being, to start with. Many times we don't follow that. When we develop know your customer, know your partner also very well, what they want, what they don't want. That is what I do every time, try to understand the other side. So that, major dispute does not feature. Then come the brass track reality when you are negotiating a contract. Make it as clear as possible. Because I have seen in my life defective contract is the creator of all disputes, very bad for in-house legal team, but very good for whom you know, external lawyers. No doubt about it. So therefore, try to see the contract drafting, whether we can make out a draft as clear as possible. Your responsibilities are known, my obligations are known, and the matter can be sorted out. If there is a dispute, I can give you hundreds of examples in my life where in most of the cases, defective contract only brought all kind of miseries with the people. So that, ultimately you are fighting wherever. So it is very important to draft a proper contract. Third thing, what I can say, I'm talking from in-house perspective, make it known to your people that we have entered a contract. Now, I am in the midst of a organization which has got 200,000 people working in 50, 60 countries around the world. So it is a very, very difficult job. We are not a small setup. But you have to make sure this contract applies to whom, go to them, explain the nuances of the contract, and also try to train people that how you can really pick up the symptom where you feel disputes may arise. And then you prepare your own escalation process. The moment you smell that there could be a dispute that is brewing up between two people, because most of the time dispute arises because I don't like the other guy. It is a purely personal. This also creates hell of a lot of problem in terms of dispute. Then I must know how to escalate, at what level, so that the dispute can be nipped in the bud itself. So that kind of mechanism should be available. That's why many companies, especially in the West, they have developed their own dispute resolution policy, how disputes can be resolved to a great extent. Mind that while a dispute is going on, and we talk about mediation, I was attending the earlier session, very nice session, mediation, when starts, when does not start. Mediation should be there all the time. There is nothing called now let us start the mediation. So therefore, try to avoid the dispute, and then when a dispute starts, address the dispute, try to resolve it at a different level so that you don't get into mediation, arbitration, litigation, and whatnot.
Thank you very much. That was quite insightful. So, have a dispute resolution policy in place for organizations, and also educate those within the organization about how it works so that they know how to escalate within the organization. And also know your partner. I think that is what brings both parties to the mediating table. So thank you very much for that. There was one thing, Mr. Mukhopadhyay, that you said, and Fraser, I'm going to come back to you for the drafting of the contract is what Mr. Mukhopadhyay spoke about. But do you think that one can introduce any sort of specificity in the arbitration clause?
It's always struck me that arbitration clauses are not very often used in a very imaginative, creative way. And it goes back to the discussion on the last panel about, is arbitration just court light? And I remember when I first qualified as a barrister, I was talking at some conference to a solicitor who specialized in arbitration. And she said, you do litigation, do you do arbitration as well? And I said, well, I haven't, but I'll give it a go. It's just like court, isn't it? Except you get to sit down and you get to have biscuits while people are speaking. And actually, the last 15, 20 years of my practice has very largely confirmed that impression. Most commercial arbitration is just a slightly more or less efficient, more or less informal method of adjudication that you'd recognize from court. It seems to me, sometimes that's quite right, that's fine, people just want a private court. And if that's all parties want, then familiar arbitration is fine. But there will be other contracts where you have a joint venture partner, for example, who you genuinely want to commit to a long-term relationship with. And it seems to me that actually the last thing that you would want to do there is get in front of either a judge in a wig in a courtroom or someone who looks very much like a judge and may well be a retired judge in an arbitration centre. And so for that sort of clause, and I've very rarely seen these, but I think there's scope for them, why not have a clause which says that the arbitrator will not just resolve disputes in a contractual way, but will have his or her own discretions to adjust pricing, to adjust the allocation of risk by reference to standard principles that can be set out in light of changing circumstances, or who can direct changes to a relationship for an orderly wind down if the arbitrator decides, according to the principles of the contract, that that's required. Why must it always be an adversarial breach, loss, damages situation? I'd be interested in others' experiences, whether perhaps that happens in other arbitrations and it's just not people like me who are instructed to argue them. But I've seen so many cases where nobody wins except the lawyers and the arbitrators. And I wonder whether if those people had thought about how they might end up when they were drafting their clause, they wouldn't just have adopted a boilerplate clause. They might have actually thought, how can we design an arbitrator's powers that can help us find a solution if we need one, rather than just resolve a dispute.
Thank you, Fraser. I think that adequately covers how can we be a bit more creative about the powers that we give to the arbitrator. And this takes us back to what Chief Justice Suryakant said this morning about party autonomy and really using it in the spirit of the arbitration rather than to orchestrate the outcome of the arbitration. So thank you, Fraser, for that. And we move to Amanda. Amanda, you have phenomenal experience. You run a company with about 1,500 experts. Can a forensic investigation make the parties see the writing on the wall? Can a forensic expert really coerce a settlement or at least nudge them towards a mediation?
Well, thank you, Krishna. I think this is a really interesting subject, and we're really talking about sort of how do we change the overall landscape. And once the facts, of course, become clearer, it really affects the behaviour of the parties in the dispute, and therefore the efficiency of the arbitration and the changes within it. So I think, do they make the parties see the writing on the wall? I think, well, yes, in some cases is the honest answer, in that it can actually affect the psychological as well as the strategic. And when you look at the forensic investigations, what that really sets out to achieve is the clarity and the chronology as well as the quantification of the disputes that you have within it, which can quite often, when you're starting on the process, actually be clouded by particularly the narrative and the emotion. So how do you really cut through that to get to the true facts that sit within it? And the priority has to therefore be the what, and then it's followed by the how and the who. So to really get to the heart of that, you've got to start to really look at the facts and break those down in terms of the data that sits behind it, and the analysis is effectively at the heart of that, which gets you the forensic investigation that you need. It's quite interesting. So HKA publishes something called the Crux Report, and we look across a whole number of disputes, around 2,200 projects, valued about 2.43 trillion, which is just phenomenal when you actually start to look at how that data can be used around sort of some of the core root causes that really affect those disputes time and time again. And indeed, when we look at the failures of what's happening there, it's usually the same failures that keep occurring around process, communication, and indeed documentation. So that's where you need that ultimate forensic analysis to sort of bring that to the fore. And what you've got to really think about is, is that when you're doing that forensic analysis, which can show both the strengths and the weaknesses in your case, actually, do you want to share that information, or is it something that you keep internally? And of course, if you're able to share the information between the parties, it can quite often change the imbalance that you have that sits between them. So you're filling the gaps by that analysis. But equally, if you're actually keeping it internal, what it can do is sharpen the strategy and reduce the litigation risk, because then the decisions are based absolutely on the facts and not the assumptions. And for me, that isn't about coercion, it's actually about illumination. So forensic investigations don't force the settlement, but they do make the likely outcome more viable. And it's how do you get to that viability at the end of the day? Similarly, within RICS, the Dispute Resolution Service really looks at where neutral evaluation and expert determination often prompts the parties to recalibrate their position and come to the table, with an open mind and to really sort of like think about the process long before maybe an arbitration actually becomes necessary. So do they actually look at improving the efficiency of the arbitration? Absolutely, they do. They narrow down the issues in terms of where the focus needs to be. I think they also look at reducing procedural sprawl, and that's a really important factor to bear in mind in terms of how you're taking things forward. But also, I think when you've got that forensic data, it can quite often prevent any late surprises in the process. So really, the answer to both questions is yes, it should be, not because forensic investigations coerce anybody, but they really get to the heart of exposing what the reality is that sits behind the dispute. And ultimately, they're not just evidentiary tools, they're engines of dispute resolution efficiency.
Thank you very much. So I think the panel is on the same page in relation to the narrowing of disputes, which can be done, it seems, in a number of different ways. It can either be done by bringing in an expert at an early stage, or by having mediation resolve a few of the issues in the matter, or educating their own, as Mr. Mukhopadhyay said. So just a couple of last comments. Nitesh, one from you. What has worked? Can you give us an example of some of the cases that you or Trilegal did during the course of last year where it's worked?
So I'll give you an example of a matter that I did 2 weeks back. So that involved, so there was a suit filed in India. My client was an English company. They were implicated as a defendant. We kept fighting on whether the service has been done properly or not, a convention and all those things. And then we reached out to the other side that can we resolve this by way of mediation, right? The clients were sort of, they said, yes, please try it. But our experience has been, India, this doesn't work. So we said, please allow us to sort of try this, right? We had, I had 2 calls with the other side. A lawyer, and they said, okay, give us the proposal. We requested the court, please appoint a mediator. In one sitting, we were able to resolve that matter. And there were other defendants, but qua us, the mediator prepared a report and said, I'm submitting to the court, matter got resolved. So the client didn't have to file anything on merits, no evidence, no trial, because they were sort of like, who will be the witness? Will our employee from UK have to travel? What about the cross-examination? We were sort of able to resolve everything, right? Just to give you another example, apart from mediation, so earlier this year, the Supreme Court of India, it laid down a landmark judgment in relation to the enforcement of foreign award. Trilegal successfully sort of represented the parties there. The Supreme Court, for the first time, laid down the doctrine of transnational issue estoppel, which is mostly, I think it's followed in England and in Singapore. First time it's been laid down by the Indian Supreme Court. They said at the stage of enforcement, don't even talk about the merits of the case, right? They've gone to a different extent altogether, right? In terms of how things have changed. Of course, we have a long way to go. But be it court litigation, mediation, arbitration, I mean, my experience has been, and that's basis sort of the matters that we do, is that if you have that right approach strategy, you are able to sort of navigate, find solution, and get that sort of commercial solution to the client. That's what they always look for.
Nitish, one last comment from the business side of things.
Thank you, Karishma. I mentioned that as a business house, we are not in the business of, getting into disputes, spending money, etc. We have got better jobs to do. Now the issue is that you can't avoid the dispute. What I am giving you practical example, being involved in such a global organization, first is we look through the contract. If it can be drafted properly, it will be good for us. Second thing, at every stage, if the relationship is very critical, you identify people who will be responsible even for maintaining the relationship while it is going on. That is what we do for our very big joint venture, etc. Third thing, what we do is that even when a dispute comes, we should have, this is where, we are only talking about mediation, arbitration, litigation and whatnot. But the desire of the parties are extremely important. If I am too much keen that I want to resolve my differences with you, I will go whole hog to see. Fourth thing, mediation, please do it sincerely, not should be some kind of tick box kind of thing. Different layers, let us give it a try. And finally, if nothing works, go for arbitration, not for litigation. And even when the arbitration goes on, we always try to see an opportunity where we can settle the issue. This is how we resolve disputes.
Thank you. So it seems that the best dispute is the one that you never have. For the others, you resolve them efficiently with all of the tips and tricks that this panel has given to you. Thank you very much.
That has indeed been an unrelenting yet brilliant array of conversations throughout the day, marked by depth, diversity, and engagement at every stage. As we culminate this conference, ladies and gentlemen, thank you for being with us on this fine Friday and for making this conference such a vibrant and intellectually engaging forum. While the formal sessions conclude here, the deliberations, we're certain, will continue well beyond this hall. We now warmly invite you all for a sumptuous lunch. Thank you. And we need a joint panel picture. Do we have the photographer around? Yeah. Just 2 minutes.
Thank you. Hey, everyone.
Can we have the backdrop on the screen? Ravi?